The last time my son-in-law saw me before the bankruptcy hearing, he had told me I had no place in that building anymore. He had said it on a Tuesday afternoon in the parking lot of the company I had spent 31 years building. He had said it with the particular confidence of a man who has recently acquired something and has not yet discovered what he does not understand about it. He had said it in front of two of my former employees, which I believe was intentional. And he had said it without raising his voice, which told me he had rehearsed it. I had stood in that parking lot for a moment after he walked back inside. I looked at the building, at the sign above the door that still said McKay Medical Distribution, because the rebranding Joseph had been planning had not yet been completed, at the parking spaces nearest the entrance that used to be mine. Then I got in my car and I drove home. I did not say a word to Joseph that afternoon. I did not call Margie. I did not call my lawyer or my accountant or any of the people I would eventually call over the following weeks. I simply drove home, made coffee, sat at the kitchen table where my wife Ellen had sat for 26 years, and I began to count. 18 months later, I walked into a bankruptcy hearing in a federal courthouse in downtown Minneapolis, and I sat in a chair that Joseph had not expected me to be sitting in. He looked at me across that room the way a man looks when he realizes that the situation he believed he had controlled was, in fact, never under his control at all. I nodded at him, politely. This is the story of what happens when a son-in-law mistakes a quiet man for a finished one. Who is Sean? My name is Sean McKay. I am 66 years old. I was born in St. Paul, Minnesota, the son of a hospital supply salesman who drove a station wagon full of sample cases to clinics and surgical centers across the upper Midwest for 28 years and who believed, with the particular conviction of a man who had earned every inch of his livelihood through relationships rather than transactions, that in the medical supply business your word was the only inventory that truly mattered. I did not start in medical supply. I spent 4 years studying biology at the University of Minnesota with the vague intention of going to medical school. Discovered in my junior year that I was far more interested in the business side of medicine than the clinical side, and graduated with a degree that I used exactly once, on the day I walked into the office of a regional orthopedic device manufacturer in Eden Prairie and told them I wanted to sell their products. They hired me on a Thursday. I started on Monday. I spent 8 years learning the business from the distribution side, calling on orthopedic surgeons and hospital procurement directors and the particular category of operating room nurses who actually decide which implants get ordered and which do not. I learned that the medical device business runs entirely on trust, that surgeons form loyalties to the representatives who show up when things go wrong, not just when things are easy, and that the relationships you build in the first years of this work will either sustain you for decades or disappear the moment you give anyone a reason to doubt you. In 1992, I founded McKay Medical Distribution with a line of credit, 1 warehouse in Brooklyn Park, and 4 product lines from 2 manufacturers who had been my clients at the previous firm and who followed me because they trusted me rather than the company. Ellen thought I had lost my mind. She said this calmly and with complete accuracy, and then she went back to her job as a school administrator and supported our family for the first 2 years while I built the business to a point where it could support itself. Ellen passed 4 years ago. She was 61, ovarian cancer, swift and unsparing. We had been married for 34 years, and she had been the most honest person I had ever known, which is the quality I valued most in her and which I miss most acutely in the particular silence of the house on Fernwood Avenue where we had lived for 22 years. By the time I retired, McKay Medical had 32 employees, 6 product lines from 4 manufacturers, and distribution agreements with 47 surgical centers and hospital systems across Minnesota, Wisconsin, and the Dakotas. The company's most valuable asset was not its warehouse or its inventory or its fleet of delivery vehicles. It was a regional distribution license issued by the State Medical Device Regulatory Board, which authorized the company to distribute Class II orthopedic implants in a 4-state territory. That license was issued in 1998 and had been renewed annually for 24 years without interruption. The license was issued in my name. I want you to remember that. Margie and Joseph. Margie is our daughter. She is 37 years old. She has Ellen's patience and Ellen's precision, and, unfortunately for everyone involved in the events I am about to describe, Ellen's tendency to believe that the people she loves are operating in good faith until the evidence against that belief becomes impossible to ignore. She grew up watching me build McKay Medical. She understood the business not in the way that people who study business understand it, but in the way that children understand things they have grown up inside of. She knew the names of the manufacturers. She knew the hospital systems by their procurement cycles. She knew, because I had told her and because she had watched it, that the company ran on relationships that had taken decades to build and that could not be transferred or replicated simply by acquiring the legal entity that held them. She had not worked in the business. She had gone to nursing school, worked for 12 years as a surgical nurse at a Minneapolis hospital, and met Joseph at a medical conference in Chicago 6 years ago. Joseph was presenting a paper on regional distribution models for surgical consumables, which was how he described his area of expertise, and which Margie had found impressive enough to give him her card at the end of the session. Joseph Carver is 42 years old. He has an MBA from a Midwestern business school, 8 years of experience in medical supply logistics, and the particular quality of intelligence that is genuinely impressive in a conference room and genuinely dangerous in a business he does not fully understand. He is not a foolish man. He is a man who mistakes pattern recognition for wisdom, who can identify what a successful business looks like from the outside without understanding why it works from the inside. He and Margie married 4 years ago. I walked her down the aisle in the church where Ellen and I had married 34 years earlier, and I shook Joseph's hand at the reception, and I told him he had married the best person I knew, which was true, and I told him I hoped he understood what that meant, which was also true, and which he did not fully understand. He joined McKay Medical 18 months before I retired, initially in a business development role that I created at Margie's request. He was good at certain aspects of it. He had genuine talent for financial modeling and a facility with data that my operations team found useful. What he did not have was the patience for the relationship side of the business, the willingness to sit in a procurement director's office for 45 minutes talking about something other than the transaction at hand, because the transaction at hand was not actually what you were there for. I noticed this and said nothing because he was new, and because I told myself that patience was something that could be learned, and because Margie was happy, and I had decided, after Ellen's passing, that Margie's happiness was something I would protect rather than complicate. That was my most significant mistake. The first sign: I retired at 64. The sale of McKay Medical to Joseph was structured as a staged buyout, meaning he paid a portion up front from a combination of personal savings and a small business loan, with the remainder to be paid over 5 years from the company's operating revenue. The total agreed price was $2.3 million, which my accountant confirmed was fair market value for a business of McKay Medical's size and profile. There was one condition I had insisted on, and which Joseph had agreed to without apparent difficulty. The regional distribution license, which was issued in my name and which could not be transferred without regulatory review, would remain technically in my name for the duration of the buyout period, after which I would initiate the transfer process once the financial obligations had been met. During that period, I retained what the agreement described as a license stewardship role, meaning I was legally responsible for the license's compliance requirements and Joseph was operationally responsible for everything else. My accountant had suggested I retain more formal oversight. I had declined because Joseph was my son-in-law and because I was 64 years old and I had spent 31 years in a business that ran on trust, and I had decided, consciously and with full awareness, to extend that trust one more time. The first sign came 8 months after the sale. My former operations manager, a woman named Carol Lindquist, who had been with McKay Medical for 14 years and who had stayed on under Joseph's management, called me on a Saturday morning. She said she was calling as a friend and not as an employee, and that I should take what she said in that spirit. I said I would. She said that Joseph had been expanding the product lines aggressively, adding 3 new manufacturers without going through the relationship process that the existing hospital clients expected, and that 2 of the larger hospital systems had already expressed concerns to her directly about the new direction. I said, "Which systems?" She named them. They were 2 of our 3 largest accounts. Together, they represented approximately 40% of the company's annual revenue. I thanked Carol. I said I would look into it. I called my accountant that Monday and asked him to pull the company's financials for the 8 months since the sale. He called me back on Wednesday with a summary that concerned him enough that he had prepared a written analysis without being asked. The inventory had increased by 60%. The accounts receivable had aged significantly, meaning invoices were going unpaid longer than was normal for the business. 2 new product lines had been added that required different handling and storage protocols than the existing Class II implants, and the warehouse had not been reconfigured to accommodate them, which created potential compliance issues under the distribution license. My distribution license. I sat at the kitchen table on Fernwood Avenue and I looked at those numbers for a long time. Then I called Joseph. "No place here." He answered on the first ring, which told me he had been expecting the call. I said I had been looking at the financials and I had some concerns I wanted to discuss. I said I thought we should meet in person. He said he was busy that week but could fit me in on Tuesday afternoon. I drove to the Brooklyn Park warehouse on Tuesday. It was the first time I had been there since the sale. The parking lot had been repainted. There was a new sign planned. I could see the outline where the old letters had been removed and the new ones had not yet been installed. The loading dock had 3 new vehicles I did not recognize. Joseph met me in the lobby. He was cordial in the way of a man who is prepared for a conversation he does not want to have. We went to my old office, which had been redecorated in ways that were perfectly reasonable and which I found, irrationally but honestly, slightly disorienting. I laid out what I had found: the inventory expansion, the account aging, the compliance questions about the new product lines and the license requirements. I said these were things that needed to be addressed and that as the license holder I had both a legal and professional obligation to raise them. Joseph listened. He was patient and pleasant throughout, which I now understand was because he had already decided what he was going to say before I finished. When I was done, he said, "Sean, I appreciate your concern, but I need to be direct with you. The way I'm running this business is different from the way you ran it, and that's intentional. The market has changed. The relationship model you built was right for its time. We're moving toward a volume model, and that requires a different approach." I said, "Joseph, the license requires compliance with specific handling protocols. That's not a business philosophy. That's a regulatory requirement." He said, "We have a compliance consultant." I said, "Who?" He named a firm I had never heard of. I said, "The manufacturers who issued the license know me personally. If there are compliance issues, they will come to me directly." He said, "Sean." He paused. He looked at me with the expression of a man who has decided to say something he has been practicing. "I bought this company. I appreciate everything you built here, but I need to run it my way. And honestly," he stood up, "you don't have a place here anymore." I looked at him for a moment. He held my gaze with the confidence of a man who believes the conversation is over. I stood up. I said, "All right." I drove home. I made coffee. I called my accountant. Then I called Trevor Marsh, who had been my attorney for 16 years. I told Trevor what Joseph had said and what I had found. Trevor said, "Sean, what does the buyout agreement say about the license stewardship role?" I told him. He was quiet for a moment. Then he said, "And the license is still in your name?" I said, "Yes." He said, "Then you're not done here. Not even close. 18 months. What I did over the following 18 months I will describe carefully because the sequence matters. The first thing I did was nothing visible. I did not call Joseph again. I did not contact Margie about the business. I did not communicate with Carol or any former employee in any way that could be construed as interference. I was, To all external appearances, a retired man living quietly on Fernwood Avenue, tending Ellen's garden, attending the monthly meetings of a medical industry retirees group I had joined the previous year, and presenting no evidence whatsoever of being a problem. The second thing I did was documentation. Trevor and I met every 3 weeks. He had engaged a compliance specialist, a woman named Dr. Sarah Okonkwo, who had spent 20 years at the State Medical Device Regulatory Board before entering private practice. Dr. Okonkwo reviewed the license requirements against what Carol and 2 other former employees, who contacted me voluntarily over the following months because they were concerned, described as the current operational reality at McKay Medical. Her assessment, delivered in a written report after 6 weeks of review, was precise and damaging. The new product lines Joseph had added included items that required specific temperature-controlled storage protocols under the Class II license. The warehouse had not been reconfigured. The compliance consultant Joseph had engaged had no Class II experience and had signed off on conditions that did not meet the regulatory standard. 2 of the hospital systems had already filed informal complaints with the state board, which I had not known. The state board, it turned out, had been attempting to contact me. Because the license was in my name, the compliance notices had been sent to my old business address at the warehouse, which Joseph's administrative staff had been intercepting. Trevor filed a formal response to the state board on my behalf within a week of learning this. I appeared before the board's compliance committee in person. I explained the ownership transition, the stewardship arrangement, and the compliance failures that had occurred without my knowledge or authorization. I provided Dr. Okonkwo's report. I provided the documentation of the intercepted notices. The board suspended the license pending a full compliance review. Without the license, McKay Medical could not legally distribute Class II orthopedic implants. Without that distribution capability, the 2 largest hospital system contracts were immediately void. Without those contracts, the revenue model that Joseph had built his expansion on collapsed. I want to be clear about something. I did not cause the suspension. The compliance failures caused the suspension. I simply ensured that the regulatory body responsible for the license understood what had actually been happening, and that the license holder, meaning me, had been kept uninformed. Joseph called me the evening the suspension notice was issued. His voice had a quality I had not heard in it before. He said, "Sean, we need to talk." I said, "I know." He said, "The license suspension. If this isn't resolved, the business." I said, "I know what happens to the business, Joseph." He said, "Can you fix it?" I said, "That depends on what you mean by fix." He said, "The board, the compliance review. You have relationships there. You could." I said, "Joseph, I appeared before that board 3 weeks ago. I told them exactly what had been happening since the sale. I provided documentation. The review is proceeding on its own timeline, and I have no ability to accelerate or influence it." A silence. He said, "How long have you known?" I said, "Since the Tuesday you told me I had no place there anymore." The silence that followed was the longest of our entire conversation. The bankruptcy hearing. The compliance review took 4 months. During that period, McKay Medical lost both major hospital system contracts, exhausted its operating credit line, servicing the expanded inventory it could no longer move, and defaulted on the 2nd year of the buyout payments to me. Joseph filed for Chapter 11 reorganization in federal bankruptcy court in Minneapolis 9 months after the license suspension. I want to explain why I was at that hearing, because it was not obvious, and because Joseph clearly had not expected it. Under the bankruptcy proceeding, the court was reviewing all assets of the business to determine what could be restructured or liquidated to satisfy creditors. The distribution license was listed as an asset of McKay Medical Incorporated. The bankruptcy trustee had valued it at $340,000. The license was not an asset of McKay Medical Incorporated. It was issued in my name. It had always been issued in my name. The buyout agreement described it as subject to future transfer, not as a transferred asset, and the transfer had never been initiated because the buyout payments were in default. Trevor had filed the relevant documentation with the court 3 weeks before the hearing. The trustee had reviewed it. The issue was on the agenda. I arrived at the federal courthouse on a Wednesday morning at 8:45. I wore the suit I had worn to Ellen's funeral, which was the last occasion I had dressed formally before retirement, and which fit me the same as it always had because I had not changed much in 4 years. Joseph was already in the room when I entered. He was seated at the table with his attorney. When he saw me, his expression went through several things in rapid sequence: surprise, calculation, and then something quieter and harder to name. I took my seat. I nodded at him. He did not nod back. The hearing proceeded. When the distribution license was addressed, Trevor presented the documentation establishing that the license remained in my name and had never been legally transferred. The trustee confirmed this. Joseph's attorney raised an objection based on the intent language in the buyout agreement. Trevor addressed it. The court ruled that the license was not an asset of the bankruptcy estate. McKay Medical's reorganization plan, which had been premised in part on the value of the license as a recoverable asset, required revision. Joseph asked to speak with me in the corridor during the recess. We stood by a window that overlooked the street outside. He looked different from the man who had stood in that parking lot 18 months earlier. Not smaller exactly, just more accurately sized. He said, "You knew this whole time." I said, "I knew the license was in my name, yes." He said, "You let the suspension happen." I said, "The compliance failures caused the suspension. I reported what I found to the board because I was legally obligated to as the license holder." He said, "You could have warned me." I said, "I tried to, Joseph. On a Tuesday afternoon in your office, you told me I had no place there anymore." He said nothing for a long moment. Outside the window, a delivery truck was making its way down the street. He said, "What happens now?" I said, "That depends on what you're asking." He said, "The license. Without it, the business can't be restructured into anything viable." I said, "I know." He said, "Is there any circumstance under which you would initiate the transfer?" I looked at my son-in-law, this man who had married my daughter in the church where Ellen and I had married, who had sat at my kitchen table on Fernwood Avenue for 4 years of Sunday dinners, who had told me I had no place in the building I had built. I said, "The transfer requires full satisfaction of the buyout agreement, $2.3 million, minus payments received to date, and it requires a compliance remediation plan approved by Dr. Okonkwo and the state board before any transfer can proceed." He said, "That's the business doesn't have that liquidity." I said, "I know." He said, "So the license just stays with you." I said, "Unless the conditions are met, yes." He looked at the floor. Then he looked at me. He said, "Margie doesn't know any of this." I said, "I know she doesn't. That conversation is yours to have, not mine." He said, "She's going to." I said, "Joseph, what happens in your marriage is between you and my daughter. What happens with the license is between you and the agreement you signed." He nodded slowly. It was a different kind of nodding from the confident certainty I had seen in that parking lot. This was the nodding of a man who has arrived at something he does not want to accept and has run out of alternative explanations. He went back into the hearing room. I stood at the window for another moment, looked at the street, at the ordinary Wednesday morning proceeding outside. Then I went back in, too. What happened after? McKay Medical filed for Chapter 7 liquidation 3 months after the bankruptcy hearing. The inventory was sold, the warehouse lease was terminated, the employees were let go with the statutory notice and severance the court required. The distribution license remained in my name. Margie called me on the evening the liquidation was finalized. She had known for some time by then. Joseph had told her, over a series of conversations that I was not part of and do not have full knowledge of, what had happened and why. She called me not angry, which I had prepared for, but with the particular exhaustion of someone who has spent weeks processing something difficult and has arrived at a kind of clarity on the other side of it. She said, "Dad, did you plan this?" I said, "I planned to protect the license. I did not plan the compliance failures or the suspension or the bankruptcy. Those were Joseph's decisions." She said, "But you knew." I said, "From the Tuesday he told me I had no place there." "Yes." She was quiet for a while. She said, "He thought you were finished." I said, "I know." She said, "He was wrong." I said, "Yes." Another silence. She said, "Dad, I'm sorry." I said, "You have nothing to apologize for." She said, "I should have seen it." I said, "You trusted your husband. That is not something to apologize for." We talked for another hour. About Ellen, about the business, about what came next for Margie, which was the conversation I cared most about. She was going back to surgical nursing. She had a position at the same hospital where she had worked before. She was going to be all right. That was what mattered. The distribution license was reactivated by the state board after a 6-month remediation period supervised by Dr. Okonkwo. I did not restart McKay Medical. I was 66 years old and I had already built it once, and I had no particular desire to build it again. What I did was negotiate a licensing agreement with a regional distributor who had the operational infrastructure to use it properly and who paid me an annual licensing fee that covered my retirement expenses comfortably. Carol Lindquist went to work for that distributor. She called to tell me, somewhat apologetically, as though she expected me to object. I told her she had made a sensible choice and that I was glad the business was in hands that understood it. The sign on the building in Brooklyn Park now says something else entirely. What I know now, I am 66 years old. I spent 31 years building a business on the understanding that trust is the only inventory that truly matters, and that relationships built over decades cannot be acquired through a transaction, no matter how carefully the transaction is documented. What I observed in Joseph was not malice. I want to be clear about that because clarity is something I owe this story. Joseph is an intelligent man who genuinely believed he understood what he had bought. He understood the financial structure. He understood the product lines. He understood the regulatory framework in the abstract. What he did not understand was that the thing that made the business work, the reason those hospital systems had stayed with McKay Medical for 15 and 20 years, was not the product lines or the pricing or the distribution infrastructure. It was the trust that had been built across 3 decades of showing up when things went wrong and not just when things were easy. You cannot acquire trust through a purchase agreement. You can only earn it the way my father earned it, driving that station wagon across the upper Midwest for 28 years, and the way I earned it, building relationships one difficult conversation at a time for 31 years. When Joseph told me I had no place in that building anymore, he was telling me that he had decided the history of the thing he had bought was irrelevant to its future. He was wrong about that. The history of a business that runs on relationships is not background, it is the foundation. And when you remove the foundation, everything built on it eventually comes down. The license is still in my name. It will remain in my name until I decide otherwise. Ellen's garden on Fernwood Avenue came back strong this spring. The peonies she planted along the back fence are blooming earlier than usual, which she would have called a good omen and which I am choosing to agree with. I have dinner with Margie every other Sunday. We do not often talk about Joseph or the business. We talk about her work, about the hospital, about the patients she cares for with the same precision and patience she got from her mother. She is going to be all right. I knew she would be. She was raised by a woman who was the most honest person I ever knew. That is the inheritance that matters. If you are a person who has built something over decades and someone has told you that your time is over and that there is no longer a place for you in what you created, I want you to hear this as directly as I can say it. The relationships you built are yours. The trust you earned is yours. The knowledge of how the thing actually works, not how it looks from the outside, but how it actually works, is yours. And no purchase agreement, no matter how carefully drafted, can transfer what belongs to you simply because someone has decided it should. Know what you hold. Hold it carefully, and wait for the moment when the person who told you that you were finished discovers what they did not think to ask about. That moment will come. Tell me in the comments, has someone ever told you that your time was over and been wrong about it? I want to hear from you.